Today we're going to talk about USCIS delayed her H-1B visa for 4 months, so she filed a Mandamus lawsuit. Approved, but still no visa after 120 days. Today is Friday, June 27th, 2025, and let's take a look at the case. So here's the case. This is a plaintiff that filed a lawsuit against the U.S. Department of State seeking to compel adjudication over H-1B visa renewal. So she had submitted her application in December of 2024 through the expedited Dropbox process. Her case has remained in unexplained administrative processing for over 4 months. Now, the complaints that she faces imminent job loss, and because of the delay, and also the delay is violates the Administrative Procedure Act. Now, I have some issues with H-1B visa, and I want to cover some of the issues that I have with H-1B visa. Number one is that H-1B is a non-immigrant visa, and it limits the job mobility of the employee, and it creates a dependency on the employer. So the H-1B visa holder is tied to their sponsoring employer, and changing jobs require a new visa sponsorship. And so if they lose their job, they have to go back to their home country with limited recourse. So losing a job can mean losing their legal status. To me, it sounds almost like the modern day indentured servitude. And so because it feels like, a lot of critics call it, like I said, indentured servitude, because many workers are unable to speak up because they are tied to this employer. The other issue is displacement of U.S. workers. So U.S. graduates, whether they have a bachelor's degree or a graduate degree, faces a tough job market, especially in the IT sector. And then companies opt for these people with H-1B rather than hiring domestically qualified candidates. The other issue is that, again, there are U.S. citizens with STEM degrees every year that are graduates. And not only that, there are experienced candidates with STEM degrees, and they have degrees in computer science, engineering, but they struggle to find jobs due to this competition from H-1B holders. And some people say that H-1B is undermining long-term domestic workforce development and devaluing U.S. education. So those are some of the issues that I have with H-1B before we get into the actual case with H-1B. Okay, let's talk about this H-1B case. So this was filed in 4/2 of 2025, and it was filed in district court. And as you can see, many of the cases are filed in District Court of Columbia. And here is the plaintiff, and they have sued all these different defendants, since they are part of the government agency. And then this complaint is a writ for Mandamus, and also in violation of the Administrative Procedure Act. Okay, so let's just dig into that a little bit. So it looks like the plaintiff is currently employed as a program manager. Like I said, I have issues with H-1B, is that there are Americans who should be, that are capable of being program managers, and then I don't understand why you need to have somebody on an H-1B to be a program manager or some of those specialists, because there are people that studied here that are qualified to take these positions. And I don't understand why people with H-1B should be given these types of roles when there are unemployed Americans who have the experience and the education that are fully capable of being program managers. But I digress. Let's just take a look at this. So, employed as a program manager, her employment was authorized through her selection qualifications as an H-1B employee. And plaintiff returned to her home country of December 2024 and applied for renewal of her H-1B visa by submitting documents with the U.S. Visa Application Center in New Delhi, India, which then sent her documents to the Consulate General and requesting issuance of the corresponding H-1B visa stamp. And then this action is brought as a result of the defendant's failure to adjudicate plaintiff's non-immigrant H-1B visa application within a reasonable period of time, and thereafter issue the corresponding H-1B visa stamp. They're saying that the plaintiff currently has a valid H-1B status, which will expire in 2027. As such, plaintiff returned to India to apply for H-1B visa and the issuance of the corresponding visa stamp in order to be able to return to the U.S. for resuming her employment. Submitted her documentation utilizing a Dropbox service under the interview waiver program in 2024, which was intended to allow for expedited processing of the H-1B visa application. Then it goes on to say that the visa application was placed under administrative processing and remains in this status now for almost 4 months without completion of processing or any explanation beyond a generic statement that the case is in administrative processing, even though her online case status showed that her case has been approved. Furthermore, it is worth noting that these types of visas are often adjudicated in a matter of days for the vast majority of H-1B applicants. And now they're saying the plaintiff is at the risk of losing her employment if she doesn't return to the U.S. by a certain time. And they list, like I mentioned, they list a couple of defendants in this. And then the venue is proper because it's a district court for the District of Columbia. Because this is where the district the defendant resides. They are saying that they exhausted all remedies. The plaintiff repeatedly requested defendants to make a final decision on her application for over 23 weeks since submitting her Form D-160. D-160 is the applicant for non-immigrant visa. And it says the plaintiff has exhausted all her remedies and supplied defendants with documents that establish this plaintiff's eligibility to receive a non-immigrant visa stamp to travel to the U.S. and resume her H-1B status. Factual allegations is that saying that plaintiff current I-129 petition for a non-immigrant worker was approved. Then she returned to India in 2024 to renew her H-1B visa and request for issuance of corresponding H-1B visa stamp. And she submitted her, it's not D-160, it's DS-160, the non-immigrant visa application. And submitted her H-1B application under the interview waiver program. And plaintiff's online case status showed her application has been approved. And it says that online case status has been changed to reflect her case had been placed on administrative processing. All right, so they're saying that it's been remaining administrative processing for over 16 weeks. Okay, so that's pretty much the case, and like I said, they're looking at the violation of the APA, and then just want to show you quickly how this was resolved. Is that this was resolved by they dismissed the case before they voluntarily dismissed it before the defendants could file an answer, I believe. And so, it may have been resolved. I am not sure because it says the complaint was voluntarily dismissed. All right. So thank you very much for your time today. If you like this, give me a thumbs up, like, subscribe. Thank you very much. Bye-bye.